This hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Today's hearing will be the third in our series of hearings on the role of administration lawyers in the formulations of interrogation policies. I want to say at the outset that the subject matter we're considering today is of utmost importance to the integrity and honor of this nation. This hearing is very important, and it will not be permitted to be disrupted by anyone in the audience for any purpose. Anyone who is disruptive in any way will be expelled immediately and without further proceedings. Without objection, the chair is authorized to declare a recess of the hearing, which I hopefully will not have to do except if there are votes on the floor. We will now proceed to members' opening statements. As has been the practice in this subcommittee, I will recognize the chair and ranking members of the subcommittee and of the full committee to make opening statements. In the interest of proceeding to our witnesses and mindful of our busy schedules, I would ask that other members of the subcommittee submit their statements for the record. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. The chair now recognizes himself for 5 minutes for an opening statement. Today we commence the third in our series of hearings on the role of administration lawyers in the development and implementation of interrogation rules, which have drawn criticism here in the United States and around the world. I think it does not go too far to say that the reputation of this nation and our standing as the leading exponent of human rights and human dignity have been besmirched by the policies of this administration. Legal memos have been written defining torture out of existence, and what almost everyone except this administration regards torture has been inflicted on prisoners. Today we will look at how these policies came into being and how they were applied. I think I speak for many of my colleagues when I say that the more we find out about what was done and how it was concerned and how it was justified, the more appalled we become. These policies have been kept from the Congress and the American people by assertions of secrecy, assorted privileges, and flat refusals to disclose what has been done and why, even in classified settings. As a result, the information that we do know has come out in drips and drabs, often through the press. That is unacceptable. We live in a democracy composed of 3 equal branches of government. No one has the right to arrogate to themselves the complete and unchecked power of the state. That simply defeats the design of our system of checks and balances, which the founders of this nation crafted to ensure our freedom and protect us from the unaccountable monarchy against which we rebelled and to which we do not want to return. Today we are joined by 2 of the architects of those policies, one testifying voluntarily and one testifying under subpoena. And I hope we will be able to have a free and open discussion of these very important questions. Clearly, we do not want to reveal classified information in this open setting, but neither will we be deterred by expansive and unjustified claims of assorted privileges. I would ask that if the witnesses feel the need to invoke a privilege, they do so judiciously and that they provide the specific basis for that claim of privilege. I look forward to the testimony of our witnesses, and I hope we can finally begin getting to the bottom of these important questions. I yield back the balance of my time. I would now recognize our distinguished ranking minority member, the gentleman from Arizona, Mr. Franks, for his opening statement.
Well, thank you, Mr. Chairman. And I thank all the panelists that are here with us today. Mr. Chairman, as I've said before, the subject of detainee treatment has been the subject of over 60 hearings, markups, and briefings during the last Congress in the House Armed Services Committee alone, of which I am a member. And I will say then, as I've said in this committee many times, torture is banned by various provisions of law, including the 2005 Senate's amendment prohibiting the cruel, inhuman, or degrading treatment of anyone in U.S. custody. Severe interrogations, by contrast, do not involve torture, and they are legal. The CIA waterboarded 9/11 mastermind Khalid Sheikh Mohammed, Abu Zubaydah, and Abdul Rahim Nashiri. The results of these severe interrogations were of immeasurable benefit and perhaps saved lives in the American society. CIA Director Hayden has said that Mohammed and Zubaydah provided roughly 25% of the information the CIA had on al-Qaeda from human sources. Even ultra-liberal Harvard law professor Alan Dershowitz wrote recently in the Wall Street Journal that Attorney General McCasey is absolutely correct, that the issue of waterboarding cannot be decided in the abstract. The court must examine the nature of the governmental interest at stake and then decide on a case-by-case basis In several cases involving actions at least as severe as waterboarding, courts have found no violation of due process. And again, these are Alan Dershowitz's words, not mine. Torture, as I've said again, should be illegal. But when severe interrogation methods that are not torture are contemplated, the law requires that their legitimacy be evaluated in context. To put some of this in context, it's useful to note that the comments of Jack Goldsmith, who formerly served as Assistant Attorney General at the Office of Legal Counsel. At a November 12, 2007 discussion at Duke Law School, Jack Goldsmith said the following, quote, "It is widely thought that the administration is exaggerating the terrorist threat for public consumption. In my experience, the opposite is true. The threat as the government perceives it is much more intense, fear-inducing, than the government lets on to the public." Mr. Goldsmith went on to say of his experience in this administration, quote, "I don't think it's right to characterize it as policymakers using the fear of an attack to try to influence the lawyers, because everyone understood those stakes, because we were all reading the same reports." Stuart Taylor has written the following in the National Journal, quote, "The CIA had reason to believe that unlocking the secrets in colleague Sheikh Mohammed's mind might save hundreds of lives, perhaps many, many more, in the unlikely but then conceivable event that al-Qaeda was preparing a nuclear or biological attack on an American city," unquote. Mr. Chairman, Mr. Taylor is correct. For example, at a May 6th Constitutional Subcommittee hearing, I asked the Democrat witness Marjorie Cohen, President of the National Lawyers Guild, how she would write a statute defining how terrorists should be treated when they refuse to provide vital information voluntarily. And I want to just have us listen to her reply.
What kind of statute would I write? I would write a statute that says that when you're interrogating a prisoner and you want to get information from him, you treat him with kindness, compassion, and empathy. You gain his trust. You get him to like and trust you, and then he will turn over information to you.
Mr. Chairman, I want you to know as sincerely as I can say that I wish that this lady were correct. I wish it were that simple. I wish it could be that way. But I would suggest that the statement she made is dangerously naive, and any successful effort to stop another devastating terrorist attack must necessarily involve a more serious and realistic response than that offered by Mrs. Cohen. And I hope our discussion today rises to a higher level of analysis. It is critical to American national security. And finally, I'd like to note that the dangers of moving back toward the failed model of treating terrorists like ordinary criminals was made perfectly clear in a recently written article in the interrogation of colleague Sheikh Mohammed. The article appeared last Sunday in the New York Times, and it makes clear how we can expect terrorists to react when they are granted the rights of criminal defendants. According to the New York Times, colleague Sheikh Mohammed met his captors at first with a cocky defiance, telling one veteran CIA officer, a former Pakistan station chief, that he would talk only when he got to New York and was assigned a lawyer. Of course, this was the experience of his nephew and partner in terrorism, Ramzi Youssef, after Youssef's arrest in 1995. Unfortunately, the Supreme Court of the United States has taken steps to grant colleague Sheikh Mohammed's wish. And I hope the Congress does not make the same mistake. Before I yield back, I would also like to ask unanimous consent that a small set of exhibits provided by Mr. Addington would be entered into the hearing record.
What? We would have liked testimony too, but without objection.
Thank you. Thank you, Mr. Chairman. I understand Mr. Addington may be referring to some of these things during his testimony here today. Electronic copies have been made available to member offices, and I thank you for your indulgence, Mr. Chairman.
Well, you're quite welcome, but what I was referring to is the fact that we normally expect witnesses to submit written testimony, and Mr. Addington hasn't done that, but has submitted these exhibits 1 through 10, which will be entered into the record. I simply want to, before we go on to our next statement, I want to defend the reputation of Mr. Dershowitz against allegations that he is an ultra-liberal. He would not so regard himself, and he did write a book recently in which he advocated torture through warrants, so he's not the best witness as to what constitutes torture. In any event, we'll now recognize the distinguished chairman of the full committee for 5 minutes, Mr. Conyers.
Thank you, Chairman Nadler, Ranking Member Franks, and all of my colleagues here. This is an important day. I'm so glad to see the witnesses that are here. Now, I don't want to begin a dialogue with Trent Franks because we have plenty of time for that. But Marjorie Cohen's response was to a question asked by Republicans on the committee. She didn't come here as a person to give us advice on what we ought to do. Someone asked her that, and that's what she said. I'm more interested in what we're going to say in response to that question, not to any individual lawyer or individual citizen. And where we want to go with another person that was given a lawyer in New York, I don't know if that's shocking to anybody. We normally provide people that are going to be tried criminally with counsel. That's been the custom in the United States for quite a period of time now. So I just want to thank the committee. This Judiciary Committee I'm so proud of, the Constitution Committee in particular, and the way we go about making history around these questions. Now, we have several points here that will be examined. We have reports stating that our witnesses today played a central role in drafting Justice Department legal opinions on interrogations. Some of those opinions have been withdrawn. But let's listen to Senator Lindsey Graham of the Armed Forces Committee, what he said last week about these memos.
What we're trying to do here today is important. Now, the guidance that was provided during this period of time, I think, will go down in history as some of the most irresponsible and short-sighted legal analysis ever provided to our nation's military and intelligence communities.
And he also said that while he thought that administration lawyers may have had good intentions, but he said they used, and I quote here, they used bizarre legal theories to justify harsh interrogation techniques, end quote. Now, Mr. Addington, Professor Yu, I come here to give you the benefit of the doubt, and we want to hear your side of it. I'd like to understand how these memos came to be written and why. I'd like to learn more about your view of the unitary executive theory of government, in which the president is supposed to be superior to some or all of the laws, or wherever that leads. I'm interested in Professor Yu's description of this public debate that he entered into of if the president could order that a suspect's child be tortured in gruesome fashion, and that his response was, I think it depends on why the president thinks he needs to do that. Or is there anything that the President could not order to be done to a suspect if he believed it necessary for the national defense? And that line of questions are all very important to me. We want to understand this, and we want to have a fair discussion about it. So thank you, Chairman Nadler, for permitting me these opening comments.
I thank the distinguished chairman. I now want to welcome our distinguished panel of witnesses today and introduce them. David Addington is the Chief of Staff and former counsel to Vice President Dick Cheney. Mr. Addington was Assistant General Counsel for the Central Intelligence Agency from 1981 to 1984. From 1984 to 1987, he was counsel for the House Committees on Intelligence and International Relations. He served as a staff attorney on the joint U.S. House-Senate Committee investigation of the Iran-Contra scandal as an assistant to Congressman and now Vice President Dick Cheney, and was one of the principal authors of a controversial minority report issued at the conclusion of the Joint Committee's investigation. Mr. Addington was also a special assistant to President Ronald Reagan for 1 year in 1987, before becoming President Reagan's deputy assistant. From 1989 to 1992, Mr. Addington served as special assistant to Mr. Cheney, who was then the Secretary of Defense, before being confirmed as the Department of Defense's General Counsel in 1992. From 1993 to 2001, he worked in private practice. Mr. Addington is a graduate of the Edmund A. Walsh School of Foreign Service at Georgetown University and holds a J.D. from Duke University School of Law. John Yoo is a professor of law at the University of California at Berkeley School of Law, where he has taught since 1993. From 2001 to 2003, he served as a Deputy Assistant Attorney General in the Office of Legal Counsel of the U.S. Department of Justice. He served as General Counsel of the U.S. Senate Judiciary Committee from 1995 to 1996. Professor Yoo received his B.A. summa cum laude in American History from Harvard and his J.D. from Yale Law School in 1992. In law school, he was an articles editor of the Yale Law Journal. He clerked for Judge Lawrence H. Silberman of the U.S. Court of Appeals for the District of Columbia Circuit. He joined the Boalt faculty in 1993 and then clerked for Justice Clarence Thomas of the U.S. Supreme Court. Chris Schroeder, or Schrader, which is it? Schrader. Chris Schrader is the Charles S. Murphy Professor of Law and Public Policy Studies at Duke University. He served in the Office of Legal Counsel for 3.5 years, including 6 months as Acting Assistant Attorney General in charge of the office. He has also served as Chief Counsel to the Senate Judiciary Committee. He is of counsel to the firm of O. Mulvaney & Myers, where he works primarily on appellate matters. He received his B.A. degree from Princeton University in 1968, and a Master of Divinity from Yale University in 1971, and his J.D. degree from University of California, Berkeley, Boalt Hall in 1974, where he was Editor-in-Chief of the California Law Review. Before we begin, it's customary for the committee to swear in its witnesses. If the witnesses would please stand and raise your right hands to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Let the record reflect that the witness has answered in the affirmative, and you may be seated. Without objection, the written statements of the witnesses will be made a part of the record in their entirety. We would ask each of you to summarize your testimony in 5 minutes or less. To help you keep time, there's a timing light at your table. Assuming it works properly, when 1 minute remains, the light will switch from green to yellow and then to red when the 5 minutes are up. I will ask the first witness, Mr. Addington, is recognized for 5 minutes for the purpose of an opening statement.
Thank you, Mr. Chairman. Just 3 quick points, 2 of which are technical. In the introduction, you mentioned that on the Iran-Contra Committee, I was working for Mr. Cheney. I was, in fact, the designee of Mr. Broomfield of Michigan on that committee. Second, I think there was a reference, and I don't remember exactly what you said, but something like being an author or involved in the preparation of the minority views in that report. I think I'd actually left and gone to the White House and the Reagan administration before it was written, and I really didn't have anything to do that I recall with writing the report. Lastly, and more importantly, Chairman Conyers mentioned he wanted to give us the benefit of the doubt, which I appreciate very much. He has a long history of being respectful and looking for the fact-finding and so forth. There's one subject in which I think there's no doubt, and I thought I would point it out, given that the hallways here are full of protests and so forth on the subject, and that is I believe everyone on this committee, and I'm certain the three witnesses, want to defend this country, protect it from terrorism. That's not a partisan issue. There are obviously differences on how that's accomplished that we'll be discussing today, no doubt, but I think everyone has that view in this group. Thank you, Mr. Chairman.
Is that, well, let me say first that I suppose I'm sorry I gave you too much credit for that 1987 or 88 memo or whatever, but is that the entirety of your statement?
Yes, thank you. I'm ready to answer your questions.
Okay. Recognize Professor Yu for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the opportunity to appear before the committee. I also appreciate Mr. Conyers' commitment to having an open and fair discussion and to clarify things for the public record. I appreciate that very much. I presented extensive opening statement to the committee in the text, so I don't have anything more. I don't want to waste the committee's time in reading it, so I'll just waive the rest of my time because I provided the statement.
It's rather unusual. You don't want to summarize the statement?
I don't need to unless you'd like me to.
Well, I think it would serve, not everyone in this room, perhaps not even everyone on this committee has read your statement, so why don't you summarize key points of it?
The first thing I just wanted to make clear in response to your comment about privilege. As you know, I've been a lawyer in the executive and legislative branches, and I have received instructions from the Department of Justice about exactly what kinds of things I'm allowed to talk about and which I cannot. I've provided a text of that email to the committee. I just want to make clear, I have every desire to help the committee, but I also have a professional obligation to the Department of Justice to obey their instructions. I myself don't have the authority to resolve any conflict that you as a committee might have with them. As a former staff member for the Senate Judiciary Committee, I would never, of course, share conversations I had with the member I worked for either. And so I understand that there could be conflict between the committee and the...
Let me just say, as I said at the outset, we understand that there are legitimate privileges, and all we ask is that if any one of the witnesses asserts a privilege, you do so judiciously, and you state the exact grounds for the assertion of the privilege. And now please summarize what you want to of your statement.
I just wanted to make it clear when we start at the beginning.
Fine.
Just a few points. One point I'd just like to make clear is that we are talking about events that happened 6 to 7 years ago. And I think it's important to remember the context within which these questions arose. Some of the events occurred no more than 6 months after the 9/11 attacks, in which 3,000 of our fellow citizens were killed. I know, having worked in the government at that time and dealt with the Congress, that members of both branches were very concerned that there would be follow-up attacks by Al-Qaeda, which is one of their trademarks. I believe we in the Justice Department, in examining these questions, did the best we could under the circumstances to call the legal questions as best we could with the materials that we had available under those circumstances. I want to make clear, we're not, and I don't think anyone in the department would make any claim of infallibility about our legal judgments. These are very difficult legal questions. I think they are the hardest questions that a government lawyer can face. And I openly accept that reasonable people can differ in good faith about their answer to these questions. One last thing I want to make clear is also that we were functioning as lawyers. We don't make policy. Policy choices in these matters were up to the National Security Council or the White House or the Department of Defense. Our job was to provide legal advice about the meanings of different federal laws, but our job wasn't to, as lawyers, it wasn't our purpose, so we were not in the business of choosing amongst different policy options. Let me say, though, and for that matter, in response to these questions about privilege and so on, I can't provide any information to the committee about why different policy choices were made because we weren't privy to those decisions. I do think, though, in the end, and I'll close here, that as someone who's seen the results of those policies, to the extent they've been publicly disclosed by the head of the intelligence agencies and the president, I think that those policies have successfully provided information to the government that have allowed this country to prevent terrorist attacks by al-Qaeda on our homeland. Thank you, Mr. Chairman.
I thank the witness. Now recognized for 5 minutes for an opening statement, Professor Schrader.
Thank you, Chairman Nadler.
Use your mic, please.
Thank you, Chairman Nadler and Mr. Franks and Mr. Chairman. It's a privilege to be here today. I'm not here to question anyone's good faith, either my two colleagues here before us today or anyone else who worked in the administration under what were extraordinarily difficult circumstances. We're all eager in providing the country the best and most effective defense against any additional attacks. At the same time, it's become clear as events have unfolded and been revealed that events have taken place with respect to how detainees have been treated, as to with respect to how military commissions have been established in their procedures, with respect to how surveillance activities have been undertaken by the National Security Agency, that we find out as events unfold that behind each of these occurrences, these policy decisions, there have frequently been a substantial legal analysis from the Office of Legal Counsel. And I have to say reluctantly that I think a number of these analyses have serious mistakes in them. And so I think it's important to look back in an effort so that going forward we can establish methods that whereby the President will be getting the best legal advice in good times as well as bad, and to do that to the extent that it's humanly possible. So I'll just make 3 points about the memoranda. This is mildly repetitive of my prepared statement, which you have, but just let me emphasize 3 points. One is I think the memoranda reflect, starkly reflect, an extreme view of absolute and uncontrollable presidential power that's been pursued by this administration, not without dissent among the lawyers inside the Justice Department and other places, but it seems that those dissenting voices don't remain around for very long, and that the prevailing view has been one in which the President is purported to have almost undefinable limits on the power that he apparently is entitled to exercise as Commander-in-Chief to control the conduct and operations of a war. Now this power, if it's applied to the war on terror, is breathtaking in its scope, because the President first has warned us, and I think it's plausible to believe that the war on terror is going to be going on for a long time. Secondly, we've defined, as we ought to, that the battlefield of this war on terror includes the United States as much as Iraq or Afghanistan. And third, the tactical, strategic decisions about how to go after terrorists, about how to interrogate them once you've detained them, about whether they can be detained for some period of time or have to be put on trial. If they're tried, what the conditions of those trials ought to be, are enormous authorities. And for the President to assert that in each and every of these respects, affecting American citizens as well as foreign nationals, as well as aliens who've never set foot on this country, that the President has unilateral and unreviewable authority even to disobey the criminal statutes that the Congress has passed and a President has ratified, is a position that's far outside the mainstream of jurisprudence in this country, of what the Supreme Court has held, and indeed what prior presidents have asserted. Second point I want to say is this is not a criticism that's been raised simply by President Bush's political opponents or by liberal law professors. Jack Goldsmith is a staunch Republican. When he came into the Office of Legal Counsel and reviewed some of these memos, He called them deeply flawed, sloppily reasoned, and overbroad. When the Attorney General, the Acting Attorney General, Mr. Goldsmith, the Director of the FBI were confronted with the national security surveillance program, they refused to reauthorize it. They refused to agree with the analysis that had been done earlier that purported to find that this was also something within the President's constitutional authority. And our understanding is that they and perhaps several other high-ranking officials in the Justice Department threatened to resign over this legal analysis. You have Mr. Goldsmith telling the story in his book of needing to review and eventually to revise or reauthorize under quite different legal analyses what he calls a small stack of these memoranda. So this is not just outsiders carping at the President. This is reflective, I think, of a deeply flawed view of the jurisprudence that ought to be applied in understanding both the strengths and the limits of what the President can do in the face of statutory prohibitions. And the last point I'll mention is just with respect to how these memos have been put together. In my testimony, I expressed some concerns that they don't seem to have followed internally in the Office of Legal Counsel the good practices that the office has tried to pursue over the years. Mr. Yu supplies some information and some more details, which I'm glad to have received in his prepared testimony. I think they still leave a number of questions in my mind that would be worth pursuing, but I see my red light is on, and I will stop at this point and perhaps be able to say more in response to some of your questions. Thank you.
Well, thank you. I thank the witnesses for their statements. And we'll now go to the questioning. As we ask questions of our witnesses, the Chair will recognize members in the order of their seniority on the subcommittee, alternating between majority and minority and between minority and majority, provided that the member is present when his or her turn arrives. Members who are not present when their turn begins will be recognized after the other members have had the opportunity to ask their questions. The Chair reserves the right to accommodate a member who is unavoidably late or only able to be with us for a short time. I will inform the members of the subcommittee that we do anticipate having more than one round of questioning. I will begin by recognizing myself for 5 minutes to question the witnesses. Mr. Addington, first of all, did you play a role in, it's been reported in several books in the Washington Post that you contributed to the analysis or assisted in the drafting of the August 1st, 2002 interrogation memo signed by J. Bybee. Is this correct?
No.
You had nothing to do with that?
No, didn't say I had nothing to do with it. You asked if I assisted in contribution, and let me read to you something I think will be helpful to you. This is an excerpt from a book that I recommend all of you.
Make it a brief one because I have a number of
I'll make it very brief. War by Other Means by Professor Yu. Page 33, 2 sentences to read. Various media reports claim that his influence, I'm the his, was so outsized he even had a hand in drafting Justice Department legal opinions in the war on terrorism. As the drafter of many of those opinions, I, Professor Yu, find this claim so erroneous as to be laughable, but it does show how wrong the press can get the basic facts, close quote. Same book, page 169.
Wait a minute, Mr. Addington, please, we don't need all these quotes. Just,
Okay.
just tell us what your role was,
Yes,
if you can.
I will.
Because you said it wasn't non-existent, but you didn't help shape it, so what was it?
Mr. Chairman, my recollection, first of all, I'd be interested in seeing the document you're questioning me about. I think you're talking about a document of August 2002.
Yes.
It'd be useful to have that in front of me so I can make sure that what I'm remembering it relates to the document you have and not a lot of other legal opinions I looked at. But assuming you and I are talking about the same opinion, my memory is of Professor Yu coming over to see the Counsel of the President, and I was invited in the meeting with the three of us, and he gave us an outline of here are the subjects I'm going to address. And I remember when he was done saying here are the subjects I'm going to address, I said good, and he goes off and writes the opinion. Now, in the course of my work, thank you, you have a copy of it? Thanks. Let me just look at it. I'll give it back to you if you know. It's August 1st, 2002, memorandum for Alberto Gonzalez, Counsel of the President, Ray, Standards of Conduct for Interrogation under 18 U.S.C. Sections 2340, 2340A. I believe that this is the result of the process I was just describing, where he came over and said, these are the subjects I'm going to address, and we said, good. Now, there's one thing worth pointing out in there, in defense of Mr. Yu, who, as any good attorney would, has, I presume, not felt free to explain and defend himself on the point, and I can do this in my capacity essentially as the client on this opinion, is it was later said about this opinion, it unnecessarily addressed constitutional issues, defenses that could be raised. You don't want to hear that, Mr. Chairman?
Not right now, because I have a number of questions and we're running out the
Please go
clock.
ahead.
The Washington Post reported that, quote, the Vice President's lawyer, referring to you, I believe, advocated what was considered the memo's most radical claim, that the President may authorize any interrogation method even if it crosses the line into torture, unquote. Is that accurate?
That the Washington Post said that?
No, not that the Washington Post said it. Is the Washington Post correct in saying that?
Could you repeat it? I have to listen closely.
That you advocated what was considered the memo's most radical claim, that the President may authorize any interrogation method even if it crosses the line into torture.
No, I don't believe I did advocate that. What I said was in the meeting we had with Mr. Gonzalez and Mr. Yu and me present, Mr. Yu ran through, here are the topics I'm going to be addressing, one of which is the constitutional authority of the President, separate from issues of statutes. My answer is good. I'm glad you're addressing these issues.
So in other words, you didn't advocate any position. You simply said, I'm glad you're going over these topics.
Correct.
Okay. Now, do you believe that the President can order violations of the federal torture statute if he believes it necessary for national security under his Article 2 or any other powers?
I'll answer that carefully, because although in common conversation we're used to using words like torture and meaning a common conversation, what we're talking about are laws here. There's a federal statute which implements a treaty.
Well, let me just narrow the question. Do you believe the President can order violations of a federal statute if he believes it necessary for national security?
As a general proposition, no. I qualify with as a general proposition because I think we all agree, in fact there was testimony here and I think some of the members of this committee agreed, that facts matter for lawyers in rendering opinions, and I wouldn't render a legal opinion in the absence, I wouldn't render one to the committee.
Well, when do you believe that the President is justified in violating a statute?
You're assuming a fact, not an evidence. I didn't say I did believe that.
You said under certain circumstances.
No, I said reserving the fact that you need to have facts in order to render legal opinions.
Are there any set of facts, excuse me,
as we said,
is there any set of facts,
Mr. Chairman,
is there any
I won't
set
be
of,
rendering legal opinions.
is there any set of facts that would justify the President in violating a statute?
I'm not going to answer a legal opinion on every imaginable set of facts any human being could think of, Mr. Chairman.
Do you believe that the torture, never mind how you define it, assume it's torture. Do you believe that torture of a restrained detainee could be allowed under a theory of self-defense or necessity?
I haven't expressed an opinion on that, Mr.
You have
Chairman.
not expressed an opinion. Do you have such an opinion?
I haven't researched the issue myself. I've relied on opinions on the subject issued by the Department of Justice.
Well, you did express the opinion, I believe, that the President could, or that his Article 2 powers as Commander-in-Chief, in effect, allowed him to take actions which the FISA statute would prohibit. Is that correct?
I don't believe I've expressed those here. I think there is a serious question, constitutional questions raised to the extent Congress, instead of helping by passing statutes to carry into execution the President's power, would instead try to block the President's power. There are court cases at the circuit level, not at the Supreme Court level, and also the Foreign Intelligence Surveillance Court of Review that refer to the President's Commander-in-Chief powers as including...
let me ask you
Mr. Chairman,
one further question. Let me ask you one further question.
Mr. Chairman, I'd ask unanimous consent to grant the Chairman an additional minute to complete his questioning.
Thank you. Without objection. Mr. Addington, Professor Yu is quoted as saying that under certain circumstances it would be proper and legal to torture a detainee's child to get necessary information. Do you agree with that?
I don't agree or disagree with it, Mr. Chairman. I don't plan to address it. You're seeking a legal opinion, and as we told you in Exhibit 4, I'm not here to render legal advice to your committee. You do have attorneys of your own to give you legal advice.
What? Well, he just said he wouldn't give me an opinion. The time, well, let's see, I have half a minute yet. Let me ask Mr. Yu one question. In your memo, Professor Yu, you talked about, in the memo that's been quoted repeatedly from August, or the Bybee memo, which you helped prepare, that severe pain, as used in the federal statute prohibiting torture, must rise to the level that would ordinarily be associated with a sufficiently serious physical condition such as death, organ failure, or serious impairment of body functions. Where did you get that from? I mean, I know that language is in a different statute, but where did you derive that that's what torture means under the federal statute?
Well, Mr. Nally, Mr. Chairman, you're referring to the August 1st, 2002 memo, not
Yes.
the
That's a quote
March
from the
2003.
Yes.
Again, I want to say, your question is, where did it come from?
No, how did you reach that conclusion? I mean, you made a very specific statement that this is that in order to violate the statute, it's got to meet this criterion.
Yes.
Where did you get that criterion from?
So let me make clear that when Congress passed that statute, there's no further definition of that phrase in the statute itself. We looked at the legislative history. There was no legislative history from the time of the passage of the statute that produced any kind of definition. There was no, the United States Justice Department had never brought a prosecution under the statute, so there'd been no judicial decisions of that language. So we applied, I think as the memo says, a canon of construction to try to find anywhere else in the U.S. Code where Congress, where you have defined those terms in any other kind of statute. And as the opinion says, and the 2003 opinion also says, we recognize that that statute was not, was on a subject that was different than the torture statute, but we used a canon of construction to try to infer from what Congress has passed in other contexts to see if it can provide some help to us in trying to interpret what I think I think that was a very difficult statutory language because there was no further judicial interpretation or congressional guidance.
Thank you. The time of the chairman has expired. I'll now recognize the distinguished ranking member on the subcommittee, Mr. Franks.
Well, thank you, Mr. Chairman, and thank you, Mr. Addington, Mr. Yu, and Mr. Schroeder for appearing here. Is it Mr. Schroeder or Mr. Schrader?
Half of my family says Schrader, the other half says Schroeder. You may take your pick.
I'll stick with your family on this one. Professor, are you familiar with the report of the 911 Commission?
Yes, I am.
According to page 132 of that report, in December 1998, the Clinton administration Justice Department issued a legal opinion authorizing the assassination of Osama bin Laden on the apparent ground that he was waging war on the United States and that assassinating him would be self-defense, not murder. Incidentally, I think assassinating him might have interfered with some of his major bodily functions. I'm just hazarding an opinion there. Do you believe that this is one of the implausible theories of defenses to criminal statutes that you decry on page 3 of your prepared testimony?
Well, Mr. Franks, I haven't reviewed either that opinion or the commission report. I do believe that if we're talking about the formulation of the defense of self-defense and necessity as it appears in the August 2002 memorandum, that yes, that's the way those defenses are articulated there are among the pieces of legal reasoning in that memo that I think are far-fetched. And I'm surprised, actually, to read in Professor Yu's testimony that he says the criminal division reviewed the memo. He doesn't say the criminal division approved of the contents of the memo. And I'd be surprised if they did. I'd be interested in knowing. And by they, I mean not only the political appointees, but the career professionals in the Justice Department. And I say that because, in my experience, the prosecutors in the criminal division labor mightily to keep those defenses as narrow as possible, as you can imagine, since they're in the business of prosecuting criminals. And in fact, in 2001, the Supreme Court had just recently decided a case that the government argued, in which the government argued that unless the defense of necessity was explicitly stated in a federal statute, it wasn't available to a defendant in opposing a conviction under a federal statute. So it surprises me to learn that the criminal division was part of this process, and yet nothing about what I think the full range of their views would be on self-defense and necessity are revealed in the memo.
Thank you. It does appear a little interesting to me that the Clinton Justice Department can issue a memo saying that assassinating someone is a self-defense for the country, but now we're debating today whether waterboarding someone like colleague Sheikh Mohammed to save perhaps thousands of Americans' lives here is the big question. Mr. Yu, let me read part of an interview that you had with Esquire magazine. In that interview, you discussed the need for precise legal guidance when you helped draft legal opinions at the Office of Legal Counsel. And incidentally, I think this is very well stated. The other thing I was quite conscious of was that I didn't want the opinion to be vague so that people who actually have to carry out these things don't have a clear line, because I think that would be very damaging and unfair to the people who are asked actually to do these things. Do you have any elaboration on that?
Mr. Franks, I think the interview speaks for itself, but let me just say now, not putting myself in the position back then, but now I think when you're called on to interpret a statute which provides language which Congress hasn't otherwise defined and the courts haven't otherwise defined, that it's important to give the client, people who have to undertake action, very clear definition of what is the best we can do of what those terms mean.
Well, I think that's what you tried to do, Mr. Yu. Mr. Chairman, I would just say, try as they might, the majority should not be spinning matters of life and death into a soap opera. The fact remains that the Special Terrorist Interrogations Program was approved through a normal process for classified covert operations. It was disclosed to the Speaker, Pelosi. She did not object at the time. It was rarely used, and it was immensely successful in preventing future terrorist attacks. Mr. Addington, is there anything that you'd like to add here?
Just one brief point. Professor Schrader mentioned that it was unnecessary or even not a good idea that Mr. Yu's opinion Mr. Bybee's opinion of August 1st, 2002 addressed the defenses of necessity and justification, and I think the constitutional issue. In defense of Mr. Yu, I'd simply like to point out that's what his client asked him to do. So it is the professional obligation of the attorney to render the advice on the subjects that the client wants advice on.
Thank you, Mr. Chairman.
I'll now recognize the distinguished chairman of the full committee, Mr. Conyers.
Thank you very much, Chairman Nadler. Professor Yu, we appreciate your appearance here today. During a public debate, it was reported you were asked if the president could order that a suspect's child be tortured in gruesome fashion, and you responded that, I think it depends on why the president thinks he needs to do that. Is that accurate?
Mr. Chairman, I don't believe it's accurate because it took what I said out of context.
I see.
The quote stopped right before I continued to explain a number of things, which I appreciate the opportunity to do.
But so far what I read was accurate, but there was more.
But it was like it stops like mid-sentence. So I didn't get to finish. I mean, I finished the sentence during the debate, but I didn't get a chance to.
Thank you. Is there anything, Professor Yu, that the president could not order to be done to a suspect if he believed it necessary for national defense?
Well, Mr. Chairman, I think that goes back to the quote you just read, because...
No, I'm just asking you the question. Maybe it does or doesn't, but what do you think?
I think it's the same question that I was asked.
Well, what's the answer?
First, can I make clear, I'm not talking about...
And you don't have to make anything clear. Just answer the question, counsel.
I just want to make sure I'm not saying anything...
You don't have to worry about not saying, just answer the question.
Okay. My thinking right now...
Yes, right now.
My thinking right now...
This moment.
Yes, this moment, Mr. Chairman, is that, first, the question you're posing...
What is the answer?
Mr. Chairman, I'm not trying to make you...
I get it, okay.
Let me answer I will answer the question.
No, you're wasting my time. Look, counsel,
I don't think
we've
the
all
president-
practiced law. Hold it. Could the president order a suspect buried alive?
Mr. Chairman, I don't think that I have ever
I'm asking you that.
given the advice that the president could bury somebody alive.
I didn't ask you if you ever gave him advice. I asked you, do you think the president could order a suspect buried alive?
Mr. Chairman, my view right now is that I don't think a president would, no American president would ever have to order that or feel it necessary to order that.
I think we understand the games that are being played. Okay, now let me turn to Attorney Addington about the ABC News reported that there was a so-called principals meeting in which Vice President Cheney sat around with other cabinet-level officials to approve specific interrogation techniques. True?
I don't know of any such meeting, Mr. Chairman. It doesn't mean one did or didn't occur. I certainly wasn't at one.
None.
I was not at a meeting that fits the description you've given.
Right. Do you feel that the unitary theory of the executive allows the president to do things over and above the stated law of the land?
The Constitution binds all of us, Congressman, the President, all of you as members of Congress, all of the federal judges. We all take an oath to support and defend it. I frankly don't know what you mean by unitary theory of government. I don't have...
Have you ever heard of that theory before?
Oh, I have. I've seen it in the newspapers all the time.
Do you support it?
I don't know what it is.
You don't know what it is?
No, and it's always described as something Addington's the great,
I see.
advocator of. Now, let me tell you where I've used the word unitary. In quoting OLC opinions, in drafting signing statements, and you will find OLC opinions that refer to the unitary executive branch. And by that, they simply mean...
I don't need you to interpret to me what other people have used.
No.
You're telling
I'm answering
me...
your question.
You're telling me you don't know what the unitary theory means.
I don't know what you mean by it, no, Mr.
You don't know what I mean by it.
Or anyone else.
Do you know what you mean by it?
I know exactly what I mean by it. And
well, what do you mean?
Sentences.
Tell me.
The use of the word unitary by me has been in the context of unitary executive branch. And all that refers to is, I think it's the first sentence of Article 2 of the Constitution, which says all of the executive power is vested in a President of the United States. One President, all of the executive power, not some of it, not part of it, not the parts Congress doesn't want to exercise itself. That's all it refers to.
Thank you very much.
Yes, sir.
The gentleman from Iowa is recognized for 5 minutes.
Thank you, Mr. Chairman, and perhaps I'd quote the chairman of the full committee and we could take the temperature down in here just a little bit. And I've always found the chairman to be a gentleman, and I point that out to the witnesses today.
I do too, sir. Mr. Chairman Conyers has a long and distinguished history.
And that is something, that's a unanimous opinion on this Judiciary Committee, I believe. And I wanted to take you back, Mr. Addington, and just simply give you a little latitude to express yourself here. The book Torture Team by Felipe Sands, which has been quoted here a number of times and seems to be the source of the criticism, refuted by at least two of the witnesses here at the panel today. And I'd ask, what do you have to say about the credibility of the information that's in that book and without necessarily impugning the author, if that could be done?
Yes, I've read the book. I can't, of course, as a witness who's under oath, address every word on every page in the book. There are things in there, as I recall from reading it, that were accurate, and there were things in there that weren't.
Professor Yu, the same question?
Sir, I haven't read the book. I did read Mr. Sands' testimony before this committee, and I noticed in the testimony he said that he had interviewed me for the book. And I can say that he did not interview me for the book. He asked me for an interview and I declined, so I didn't quite understand why he would tell the committee that he had actually interviewed me.
And with that answer, Professor Yu, then I'm going to interpret that to mean that at least with regard to that statement that he had interviewed you, you find that to be a false statement, and that would perhaps reflect on the veracity of the balance of the book.
I can't tell what else is in the book, but I don't understand why he would say that he interviewed me for the book. I can tell the committee that he contacted me once. He wanted to interview me for the book, and I said, I don't want to talk to you. I wrote my own book. You can look at my own book. Everything I have to say is in my book. And then he told the committee that he'd interviewed me.
Thank you, Professor Yu. Let me just take this a little bit a different way. And you know, we're here, Constitution Subcommittee of the House Judiciary Committee, reviewing apparently the process by which the administration reached a conclusion, which seems to be a little bit amorphous at this point, and it's still in the middle of a war, trying to put it within the context of 2008 rather than the context of 2001, with the smoking hole at Ground Zero still a smoking hole, with the reconstruction of the Pentagon not perhaps yet begun, and in an entirely different environment. And I would make this point that without regard to constitutionality or statute with regard to torture, there was a different environment and a different context with which the president had to make decisions. And I believe, reliably informed that the president has taken the position consistently that prisoners will be treated humanely. Now, that definition of humane may be up for question, but within this context, it's a similar context with which we went in to liberate Iraq. And I will make this point, that had the president not taken action, if the president had said, we're going to make sure that we treat every prisoner with the idea of the advice that the ranking member of the committee put up on the screen at the beginning of, and during his opening statement, that we're going to make friends with them and cuddle up to them and gain their trust, and then we'll find out everything we need to know, and we can surely rely on somebody we're nice to tell us the truth. If the president had taken that approach, and if the president had also taken the approach that in spite of the global evidence, the global intelligence evidence of the weapons of mass destruction that Iraq had, if he had either said, I don't believe that exists, and if we do send troops, they're going to go in without, let's just say, weapons against chemical weapons, or without defense against chemical weapons of mass destruction. If the president had misstepped anywhere along the way and misinterpreted that very cautionary evidence that was out there, and we had been attacked again by the terrorists, which we have not effectively been so on this soil since September 11th of 2001, any little trip along the way would have been turned back on him as having either not taking action against weapons of mass destruction in Iraq, or not extracting the intelligence that was necessary to protect the American people from a terrorist attack. If he had been soft on this, the president might well be brought before this committee, or at least as the subject committee. We might have seen another series of hearings like we saw in this same room in 1998 if the president hadn't taken action. And I would ask Mr. Addington if you'd care to characterize this within the context of the circumstances during the time that's at question here today.
Yes, Mr. Chairman. I'm careful in doing so because of the point I made at the outset, that everyone here, I recognize, wants to defend the United States of America and their constituents from attack. The chairman, for example, lost several thousand in his district. He has the Twin Towers in his district, so I don't want to appear to be lecturing on, I care more about protecting Americans than you do, and I don't, and I know you don't either, Mr. Franks, want to be seen that way.
It's okay.
I'm sorry, Mr. King. Thank you. I looked, I should say, through basically three filters as we considered these kinds of issues back, as you say, when they were still smoking, the Twin Towers and the Pentagon. The first filter in deciding what we have to do is support and defend the Constitution of the United States. We all have to start there. Every one of us, members of Congress, me, everybody in the executive branch, takes the same oath. That's where we all start. You have to take the oath to support and defend. The President has a different oath, but the rest of us all took the oath to support and defend the Constitution. The second filter you look through in deciding how are we going to approach these issues, at least I did, was how, within the law, and I emphasize that, within the law, I help maximize the President's options in dealing with it. Third filter is when you go to war, you ask a lot of people to do very tough things. On this committee, I know there's some veterans, chairman, Conyers, I know, served in the Korean War era, and there are others who served. You ask people to do, young men to do tough things, young women to do tough things in wartime. Same with our intelligence agents. You want to make sure that whatever orders they're given, they're legally protected. You don't want to find out later somebody thinks, oh, let's investigate that, maybe they're wrong. You want to be careful about it. So everything we did in that era, at least that's what I carried in my head to measure recommendations or legal advice as they were going through. Now, the one thing I would add to what you said, Mr. King, is things were different back then. You know, the smoke's still rising. It was fresh in our memories that 3,000 Americans were just killed by al-Qaeda terrorists, and that's true. Things are not as different today as people seem to think. We're dealing with intelligence on threats every day. We have to consider these things. Now, it can be legitimate judgments and disputes, and this committee has had them and go on throughout the government about what combination of activities should deal with these sorts of things. But no American should think, we're free, the war's over, al-Qaeda's not coming, and they're not interested in getting us, because that's wrong.
I thank you, Mr. Addington, and all the witnesses. Mr. Chairman, I yield back.
I thank the gentleman and now recognize for 5 minutes the gentleman from Alabama.
Thank you, Mr. Chairman. Gentlemen, thank you for coming today. Mr. Yu, I have not read your book, but I did you the courtesy of reading your opening statement, and I want to have some conversation with you about it. In your opening statement, your written statement, you make the observation that it was your analysis, 2002 rather, that the anti-torture statute passed by Congress in the 1990s, the interpretation of that statute would depend, as you put it, quote, not just on the particular interrogation method, but on the subject's mental and physical condition. I interpret your observations as meaning that the test of torture is in part a subjective standard, that one has to do an inquiry into what you describe as the subject's physical and mental condition. Now, in response to Chairman Conyers' questions, you said that interpretation did not come from legislative history because there was very little. You said it did not come from reviewing judicial opinions because there were none. And your phrase today was that there was very little or there was no congressional guidance. No congressional guidance. One good source of congressional guidance is members of Congress. So I would ask you if you or, in your knowledge, anyone else in the administration consulted, for example, the chairman of the House Judiciary Committee, Mr. Sensenbrenner at that time, a Republican, about the meaning of the anti-torture statute.
Mr. Davis, thanks for the...
That's a simple question. Was Mr. Sensenbrenner consulted?
First, I just want to correct one thing I said that you quoted, just to be clear. There are judicial opinions on a related statute called the Torture Victims.
I understand that. Was Mr. Sensenbrenner consulted?
I would not know one way or the other.
Mr. Addington, do you know if Mr. Sensenbrenner was consulted? That's a simple was he or wasn't he?
Yeah, I did not consult him, and I do not know whether anyone else did or did not.
The chairman of the Senate Judiciary Committee, I believe, was Mr. Specter, a Republican. Do either of you know if Mr. Specter was consulted regarding the meaning of the anti-torture statute?
I did not consult him. I don't know whether he was or wasn't.
Mr. Yu, do you happen to know?
Not necessarily relevant to the legal interpretation.
Mr. Yu, do you happen to know if Chairman Specter was consulted?
I don't know one way or the other.
And there's a process that's been alluded to today of consulting with members of the House and Senate Intelligence Committees regarding certain matters that, frankly, we wouldn't want disclosed in open forum. Mr. Yu, did you or anyone else in the administration consult members of the House or Senate Intelligence Committees regarding Congress's intent regarding the anti-torture statute?
All All I know is what I've read in the newspaper.
That is a simple were they or were they not consulted? Do you know if they were?
Again, all I know is what I've read in the papers about it.
To your knowledge, were they or were they not consulted, Mr. Yu?
You mean, to my knowledge?
Yes.
I-
To your knowledge, they were not, were they?
I don't know.
Mr. Addington, to your knowledge, were any members of the House or Senate Intelligence Committee consulted regarding the question of Congress's intent regarding the anti-torture statute?
There is no reason their opinion on that would be relevant.
Is that
To
a
my
no?
knowledge, I did not consult them, and I do not know whether...
Now, let me thank you all for answering those questions without too much struggle. One of the interesting things here today, Mr. Yu and Mr. Addington, is that, frankly, we've heard this word context over and over again. And I've heard both of you say, I've heard my colleagues and my friends on the side of the aisle say, you got to remember the context. We had been threatened, we'd been attacked, there was a possibility of follow-up attacks. All of that's accurate. But let me tell you the rest of the context. You had a Congress that was a rubber stamp for the administration's entire security agenda. You had chairmen of the House and Senate Judiciary Committees who were strongly supportive of your agenda. You came to Congress and asked for the Patriot Act, and you got it, easily. You came to Congress and asked for an authorization of force resolution, and you got it, easily. You got bipartisan support for both of them. The 107th, 108th, 109th Congresses, there was not a single time the Bush administration was rebuffed on any issue related to national security. You got an expansion of FISA that met your interests. You got a Military Tribunal Commissions Act that met your interests. We wouldn't be here today, gentlemen, if you had come to this Congress and you had said one of two things. Either give us a stronger, clearer definition of what torture means, or if you'd even gone to congressional leadership and said, you're a source of guidance on what Congress meant. Tell us, Chairman Sensenbrenner. You were there. Tell us, Chairman Specter. You were there. The problem, Mr. Addington, I'll direct my last observation to you because you still serve with this administration. When you've got a Congress that's a rubber stamp for what you want, you ought not be disrespectful of the legislative branch of government. If you had come to this Congress, everyone in this room knows to an absolute certainty they would have given you anything you asked for in October 2001. If you had said, give me a definition that fits, if Mr. Yu had written the statute, if he had said, give us a torture statute that makes torture a subjective condition depending on the person's mental or physical state, you could have gotten that. You didn't even trust people who were rubber stamps for you. And I'll yield back the balance of my time.
I thank the gentleman. I now recognize for 5 minutes the gentleman from Minnesota.
Mr. You wrote the Bybee memo of August 2002. Is that right?
Mr. Ellison, as I described in the opening...
I need a yes or no, sir.
I did not write it by myself.
Did you write it at any part?
I contributed to the drafting of it.
Okay, so you contributed to a drafting of it. What percentage of the drafting did you write?
It's difficult for me to...
And you
say
checked in with Addington about what you were going to cover? He said you did.
Can I, we're talking about the August 1, 2002 memo.
Of course. Did you check in with Addington as he just said you did?
I unfortunately do not have the same legal guidance as Mr. Addington does because the Justice Department has told me I'm not allowed to talk about any individuals. I'm only allowed to talk about...
Was Mr. Addington telling the truth when he said you checked in with him over what you were going to cover?
Let me describe it.
I know. I want you to say yes or no.
I gave the draft of the opinion to the White House counsel's office, which would be...
So when he just said you came in to tell us what he was going to cover, you cannot confirm that. Is that right?
No, I'm not saying that at all, Mr.
We'll answer my question. Say yes or no.
And so it's up to the White House counsel to decide who within the White
Stop,
House...
sir. I'm asking you to tell me to confirm whether what Mr. Addington reported to this committee was right or not right. That's simple. I hope this isn't coming out of my time, Mr. Chairman.
We're a little flexible.
Who else?
Mr. Ellison, I'm afraid I have to follow the guidance provided by the Justice Department on this question.
So confirm what Addington said, deny what Addington said, or say I cannot answer the question, and what privilege are you asserting?
I can't answer the question because of the instruction by the Justice Department.
Thank
that
you.
I'm not allowed to
Thank you.
discuss.
Who else was present when Addington, when you checked in with Addington?
Sir, you're assuming I answered your last
Is that a
question.
repeat of the last answer? Do you repeat, do you stick with the last
The
answer
question
you
was,
gave?
who else was in the room when I checked in with Addington?
Right. And you can assert your privilege again if you choose, do you?
It's not my choice. The Justice Department has told me I can only talk about the office.
So at some point, this 2002 memo was implemented, is that right?
What do you mean by implemented, sir?
Well, do you know what the word implemented
The
means?
gentleman will suspend for a moment and stop the clock, please. Professor, are you asserting a privilege?
On the last question of the previous two,
Either one of them.
the first two he asked me I have to because of the instructions by the Justice Department that I can't discuss internal deliberations. I can
And
discuss-
exactly what privilege are you asserting?
I assume the Justice Department, I can't say what the Justice Department's belief for the,
No, wait a
they
minute.
ordered me not to discuss.
Well, hold on. You're testifying before a congressional committee.
Okay.
The Justice Department cannot order you, with regard to your testimony, it can instruct you to take a privilege if you are entitled to a privilege. You can take the privilege without their instructions if you're entitled to the privilege. If you are asserting a privilege, you're entitled to do so, but we're entitled to ask you what privilege it is you're asserting.
Yes,
So, and whether they're ordering you to assert a privilege or not, if the privilege is there, you can assert it. If it isn't there, you can't assert it, whatever they say.
I believe it's the attorney-client privilege, sir.
So you're asserting the attorney-client privilege and not answering the question you were asked. And we will take that, since you are not here under subpoena, we will take that under advisement and consider that at the end of the hearing. We'll resume the questioning, and the clock will resume.
Mr. Yu, are you denying knowledge of what the word implement means?
No, I wanted to know.
What does implement mean, sir?
You're asking me to define what you mean by the word?
No, I'm asking you to define what you mean by implement. What do you understand the term to mean?
I mean, it can mean a wide number of things.
Okay, look, you contributed to the writing of the 2002 memo, is that right?
Yes, I do.
The name on the memo was Bybee, but you contributed to the memo, right?
Yes, sir.
The memo was implemented at some point, is that right?
What do you mean by implemented, sir?
What I mean by implemented is the guidance that was set forth in that legal memorandum was followed and put into action. Do you understand what I mean by implemented now, sir?
So you're asking me, was the
I
memo
just told you.
followed? Was the memo followed by?
I'm not going to get into semantical games with you in this 5 minutes. I need you to answer the question or refuse to. Was the memo implemented?
The memo was signed and provided.
I know what
to the client.
signed means, and so do you. Stop wasting my time, Mr. Yu.
I'm not trying to, sir.
Was the memo followed? Will you accept followed?
I don't have personal knowledge about how it was followed, but I expect.
I didn't ask you about how. I asked you whether it was followed, sir.
Sir, you're asking me about things that other people would have done, not me.
So the fact is, so the memo was never put into effect. Are you making that claim?
No, sir. Let me go back and refer to my opening statement.
Forget it.
again.
Mr. Schrader, do you understand what implement means?
I think I do. Yes, sir.
Was this memo, this 2002 memo, which Mr. Yu refuses to answer questions about, ever put into effect?
Of course, I have no personal knowledge. I wasn't in the
I'm not asking you about personal knowledge. I'm based on your study.
My understanding is that the memo was prompted, at least in part, by a specific request of the CIA with respect to what kinds of procedures their operatives would be able to use in interrogating some high-level al-Qaeda detainees. And that once the advice was forthcoming, my understanding, it's all from published investigative reporting, I have no firsthand knowledge myself, is that some of the techniques that fell on the legal side of the line, according to the memorandum, were employed.
So is that right, Mr. Yu? Were the legal techniques that you outlined in this memo employed?
were the techniques that were legal. No, let me say this. We did not make decisions about policy.
I didn't ask
We
you about
choose
that.
the
I did
policy.
not ask you about that, sir. I want to know if the legal advice that you gave in that memo was followed, or if you expected it was followed.
You know, again, Mr. Ellison, I don't...
Did anyone ever come to you and ask you for an interpretation of your memo?
Interpretation of my memo?
Did the interrogators ever come back and say, we got the memo?
Without objection, the gentleman will have one additional minute to finish this line of questioning.
Did the interrogators ever return to you and say, you know, you've given us this memo, but we want to implement a certain technique? Do we fall within the memo? Was that scenario ever played out?
Again, sir, because of the instructions of the Justice Department, I can't tell you... That's not my clock, I assume.
Mr. Schrader,
I can't-
Mr. Schrader, was the memo in effect during Abu Ghraib?
The gentleman will suspend again. Professor Yu, are you asserting a privilege? What was the question? What was the question? Okay. I heard.
Sir, I'm afraid Mr. Ellison's questions may involve a discussion of classified information, which, because of congressional statute, I'm not at liberty to discuss in a public
So
setting.
you were asserting the privilege against the revelation of classified information in answering your question?
I don't know if that's a privilege. I just can't do that, sir. I'm not saying it's a privilege. I just can't. That's a violation of the law.
Well, so you're asserting that in order to answer Mr. Ellison's question, you would have to reveal classified information?
I might have to, sir.
Might have to or do have to? Can you, let me rephrase the question.
As I understand the question,
let me rephrase the question. Is there any way you can answer Mr. Ellison's question without revealing classified information?
Yeah, as I understand the question, I would have to discuss classified information to provide him a complete answer. I don't think I can do that, sir.
Well, again, we'll take that under advisement.
Mr. Chairman, may I make a parliamentary inquiry? I make a parliamentary
yes.
inquiry of the chair.
The gentleman will state his parliamentary inquiry.
I would inquire of the chair, after we come back from our break, from voting on the floor, if the chair would consider directing, particularly the two government witnesses, Mr. Yu and Mr. Addington. I have noticed, Mr. Chairman, I've been on the committee for a year and a half. I've never seen two witnesses, frankly, struggle as much to appreciate ordinary use of terms and questions. Would you consider instructing the two witnesses to answer the questions that they're asked, and if they wish to elaborate or clarify them, they can ask to do so, but given that we have time constraints, I would ask that the chair admonish the witnesses to err on the side of being responsive as opposed to constantly quibbling over word choice, because I've never seen it to the degree I've seen it today.
I will certainly consider that as we break, which we will recess in a few minutes for the votes on the floor. The gentleman can finish his questioning.
My question is, when the interrogators were the ones who were addressing the witnesses who were being interrogated, were those individuals, did they have a lawyer that they could go to ask about guidance as to what they could do or could not do under the guidance of the memo that you contributed to writing?
Mr. Ellison, as I understand the structure of our government, the CIA has its own general counsel's office, and I believe it's about 100 lawyers. So I assume you believe that the CIA conducted interrogations, and if you did, they have a general counsel's office to ask legal questions.
Were you ever asked questions about whether certain techniques or others were permissible under the guidance you gave in that memo?
As I said to the chairman just a second ago, I'm afraid I think your question asked me...
You're asserting a privilege. Were you ever asked whether waterboarding was permissible under the advice you gave?
Sir, if you let me finish, I can't answer your question because
Okay.
I believe it...
The gentleman will
classified
suspend again. Okay, you're asserting that you cannot answer the question as to whether the CIA asked you questions regarding the legality of waterboarding without revealing classified information. Is that your assertion?
Yes, sir.
Okay.
Did your
We will
memo
hold that under advisement, and the gentleman's time has expired.
One last question.
Without objection, the gentleman will have 30 seconds additional.
Did your memo allow for the use of sicking dogs on interrogated individuals?
I'm afraid I have to give the same answer, but I will point to
Excuse me a second. The question was, did your memo allow for that? That's not confidential. Your
Mr.
memo has
Chairman.
been revealed to public.
Mr. Chairman, parliamentary inquiry.
1 second, let him answer the question.
Sir, you're referring again to the August 1st, 2002 memo. The memo speaks for itself. It does not discuss what you just mentioned.
Thank you. The gentleman's time has expired. The gentleman,
Mr. Chairman, I just simply want to make the parliamentary inquiry, the procedure here, whether who's actually asking the questions, and if the privilege of the chair is reflective of the executive privilege that has been denied the President of the United States. I just can't keep with the flow when the chair is asking questions on behalf of the member who's been recognized.
excuse me, the chair was not asking questions, but trying to ascertain what privilege is being asserted, and at one point, trying to clarify so that we don't go back and forth with misunderstanding, and I think I saved a little time. The gentlelady from Florida is recognized for 5 minutes, after which we will recess.
Thank you, Mr. Chairman. Mr. Addington, there are press reports that state that in September of 2002, you and other administration lawyers visited Guantanamo Bay. A JAG attorney in Guantanamo, Diane Beaver, is quoted in a Vanity Fair article as saying that the message from you and the other visitors was, do whatever needed to be done. And just weeks after that visit, interrogators at Guantanamo Bay began developing a far harsher interrogation program than they had ever used before. Did you visit Guantanamo Bay in September of 2002, as has been reported?
I don't remember the exact date, but I went there a number of times.
Well, do you recall going to Guantanamo Bay around that time?
I really don't remember the dates, ma'am, but I remember going in the same
How many
year.
times did you go to Guantanamo Bay during that period?
During that, well, I'm not sure what period you're describing. I'd say I've probably been to Guantanamo, I guess, maybe 5 times. First time would have been years ago, which isn't relevant to this, when I worked at the Department of Defense. And then I've probably been, I would guess, 3 or 4.
On one of those trips, did you meet with JAG attorneys?
I didn't recall it. I remember when Ms. Beaver, Colonel Beaver, who was referenced, I think, in Mr. Sand's Vanity Fair article. I did not remember meeting her there. The only time I remember meeting her is over at the Office of General Counsel of the Department of Defense many years later.
What generally prompted your trips to Guantanamo Bay when you
I was
made them?
invited by the Department of Defense to go and accepted. I thought it would be good to go and see what they were doing to implement the decisions made in January and February at the White House to have detainees held there by the Department of Defense.
Did you have any discussions on those trips about interrogation methods?
I don't know about methods. I would say we probably did, only in this sense I can remember, and I'm not sure it's this particular trip, but at least on some of the trips, and it may have
On
been-
any of the trips?
Yes, that they would show us an interrogation room with no one in it, so you could see what the room looked like. And then separately look through, and I assume, and I don't know, that the person being interrogated and the interrogator couldn't see us. In other words, like a one-way mirror kind of setup where you could see into that. So having done that, I'm sure they must have discussed...
On any of the trips, did you discuss interrogation methods that were directly referenced in the memo that we've been discussing here at this hearing?
I'm not
Specific
actually
types
sure I remember this memo having methods discussed in it,
Did you
frankly.
discuss specific types of interrogation methods that interrogators should use while at Guantanamo Bay on the detainees?
I don't recall doing that, no.
That means you didn't, or you don't recall doing it?
It means I don't recall doing it, as I said.
Well, it's hard to fathom that you would not have a recollection on specific conversations about types of interrogation methods as opposed to just generally talking about interrogation.
Is there a question pending, ma'am?
The question is, I don't believe that you don't recall whether you discussed specific interrogation methods. So I'll ask you again. Did you discuss specific interrogation methods on any of your trips to Guantanamo Bay with people who would be administering the interrogation?
And as I said to you, I don't recall. Let me be clear to you that there are 2 different things that may be helpful to you in asking your questions. The Department of Defense
I really don't need
interrogation.
assistance. I really don't need
CIA
assistance in asking
program.
my questions.
Well, the CIA program, and you'll find when you question me, the participation with respect to the CIA program is more extensive than the DOD program. And you wouldn't
I-
find it so unusual that I don't recall the particular
Okay,
details you want
except
me
that
to recall.
interrogation, your there is an accusation that interrogation methods went far beyond and up to and past torture following your visits to Guantanamo Bay. So I'm trying to get a sense of whether you actually went there, encouraged those specific interrogation methods, and whether they crossed the line.
Yes,
So
and I did not.
I'm pretty clear on why I'm asking you the questions and which one I'm asking you. On one of the trips that you took, it was weeks after the August 1st, 2002 interrogation memo was issued by the Office of Legal Counsel. Did you have any discussions on that trip about that recent Department of Justice legal advice on interrogations? Did you ever discuss the memo which offered legal advice on interrogations with anyone at Guantanamo Bay on any of your trips there?
I'm fairly certain, I won't be absolute, but fairly certain that I did not
That you did not ever discuss?
discuss this August 1st, 2002 legal opinion to the Counsel of the President from the Department of Justice.
So you deny the suggestion in the Vanity Fair report that you encouraged Guantanamo Bay interrogators to do whatever needed to be done?
No,
And-
yes, I do deny that.
You do deny that?
Yes, that quote is wrong.
Okay. Did you observe an interrogation during the trip, as has been reported? Or did
I
you?
think we probably did, as I described earlier.
And why did you observe an interrogation?
The Department of Defense took us around to show us the camp and what was going on, showed us that. Now,
What did
I
you-
emphasize, I'm not sure it's the particular September 2002 trip you're describing, but on at least several of those trips.
What did you observe?
Observe a detainee in, I believe, an orange jumpsuit, sitting in a chair.
What kind of interrogation was used?
They were talking to him during the brief time that we went through
Simply
there.
just conversation?
During-
No other method
During the
but
brief time that
conversation?
we were there, yes. And I don't recall that we could actually hear what was being said. You could look and see mouths moving. I inferred that there was communication going on.
But you saw no physical contact with the interrogators? The only thing you
Correct, but it
witnessed
was a very
was
brief
questioning?
look, yes.
Okay. I yield back the balance of my time.
I thank the gentlelady. There are now 3 votes on the floor. The subcommittee will stand in recess until immediately after the third vote. We ask the witnesses to remain. We thank you for your participation and for your indulgence and patience. The committee's in recess.